Previously, on the practice.
When we ask you, did your sister seem suicidal? A response of, I didn't think so, isn't gonna do it. She was murdered. If you know it. She did not commit suicide. You absolutely know it.
She said that if she turned up missing, that I should call the police, because Scott probably did something to her.
Objection!
You want me to sign this? An affidavit saying I coached a witness to lie?
He made that stuff up about his sister being afraid.
Helen, I told him what his testimony needed to accomplish. I never said lie.
I'm convinced that Kyle Barrett lied on the stand after being coached by the prosecution.
I don't think Mr. Bay crossed the line. I see no evidence that he solicited perjury. The conviction, therefore, stands.
This thing was built to bring children joy, and it's toxic.
We have consistently found that it does not pose an unreasonable risk to either children or adults.
I have a boy whose body convulses, and a daughter who keeps falling down, and a son who can't read, and you people have known for 30 years.
We find in favor of the plaintiff and order the defendant to pay damages in the amount of $72 million.
I'm granting defense's motion to remit. The knockdown number is 135 per child.
That's less than they offered.
I don't care. Your case was pure speculation, counsel.
We have a right to a new trial.
If you take a new trial, you'll be right back before me, Ms. Frutt. And if you do win, I might remit the next knockdown to 75,000.
I'm gonna get him. That judge, I'm gonna get him.
$60. That's something.
You don't have to do that.
Take it. You pay me back when you get it. Listen, Jennifer, you're a smart girl, a good girl. I can judge character. Don't be doing this.
Thank you.
Go. Wipe that stuff off your face.
I will pay you back.
Yeah. Well, in the meantime, get a paper out or something. Don't be doing this.
Jimmy.
You're having a kid? You didn't tell me that.
I didn't want you to get mad.
How could you still be doing drugs?
It was just this one time. Billy left me. He left me like this.
What about rehab?
I called that number that you gave me, but they said that I couldn't interview for 2 weeks. And then I lost the number.
How far along are you?
8 months. Can't you get me out? Jimmy.
You're smoking crack with an 8-month baby.
It was just once, I swear.
No, it wasn't.
Jimmy, I'll do the rehab. I'll do anything that you want me to do. Please just get me out.
If I get you out, and I'm not saying I can, but if I do, you go into rehab immediately, straight from the courthouse.
I promise.
Tell me about the arrest.
Okay, everyone, let's get started.
Somebody make it official that you're in charge?
Brain's beauty and character. Don't knock it.
Okay, let's go. Jimmy.
Jennifer Cole, possession of crack cocaine.
Again?
I got a motion to kick at 9. She's 8 months pregnant.
What? And she's smoking crack?
Believe me, I tore into her already.
She better hope her baby doesn't die. She could be charged with murder. Did you tell her that?
I'm not positive I did, but I will. Thank you, Lindsay.
She should be shot.
All right. Beck, how's the research coming?
Okay.
Can you give me something a little more than okay? I'm seeing Scott Wallace later.
Sure. We can argue reversible error when Judge Wolf didn't have an evidentiary hearing on whether Richard Bay suborned perjury. Now, since we have Helen Gamble with us, I think that's our best shot.
What else?
Well, the neighbor's testimony that he heard lots of fights between Scott Wallace and his wife, prior bad conduct, inadmissible. We can argue reversible error there, too.
All right.
Lucy, keep dogging the clerk's office. Eleanor, jump in with Rebecca on the brief.
I can't, actually. I'm a little jammed.
Not on my calendar, you're not.
I have an appointment with the chief judge of the district court today.
About what?
Judge Aldrich.
I didn't know.
I'm keeping you out of it.
Eleanor, we can't afford to be alienating.
It's one meeting. The appointment's made. I'm doing it. Aldrich was out of line. I'm not staying quiet. Forget it.
I was observing 4323 South Holden Green. It's a known crack house. I witnessed Jennifer Cole exiting. She was stumbling and disoriented, her appearance consistent with being under the influence of drugs.
What did you do?
I exited my vehicle, approached the suspect, identified myself as a police officer, and then engaged her in conversation. Her behavior confirmed my suspicion that she was high.
Could you describe that behavior?
She was sweating and jittery and was slurring her speech.
What did you do then, officer?
I conducted a quick pat-down search for weapons, and I could plainly feel an object in her jacket pocket. It was immediately apparent to me that the object was a rock of crack cocaine.
How did you know?
Well, I've received extensive training in recognizing crack. I felt a small object, asymmetrical, rough edges, a rock of crack.
Then what?
And I reached inside the defendant's jacket and removed approximately 100 milligrams of what was determined to be crack cocaine, wrapped in paper.
This rock of crack, how big was it?
About a ½ inch in diameter.
So that's no bigger than what, an aspirin?
About that size.
And this tiny little thing was, as you put it, wrapped in paper?
That's correct.
In fact, it was inside a scrunched up brown paper bag, right?
Yes.
And the bag was inside a jacket, a big winter overcoat, in fact.
I don't recall exactly.
Officer, I'm showing you what's been admitted as People's 3. This the jacket Miss Cole was wearing?
Looks like it, yeah.
So, you do this one pat of Miss Cole's body, through this thick down overcoat and through a crumpled up paper bag. You feel this tiny little lump and you immediately know it's crack cocaine.
Yes.
No way it was jewelry, candy.
No.
All this from just one pat?
Yes. We received comprehensive and extensive training.
How many times have you used these comprehensive and extensive training techniques to frisk suspects for crack cocaine, officer?
Probably 10 times.
And how many arrests resulted from these comprehensively trained pat-downs, officer?
2 or 3.
So the other 8 people you frisked were innocent? Nothing further, Your Honor.
Ms. Alexander, the witness may step down. Does the Commonwealth have anything else?
No, but I would like to remind the court that in addition to pat-downs being constitutionally permissible, this woman is 8 months pregnant, and I would like to ask the court to seriously consider the consequences
The charges against Ms. Cole are dismissed without prejudice. You bring me some new evidence, you can refile. Ms. Cole, you are free to go.
I want to thank you, Your Honor, for being gracious enough to see me.
Well, there was nothing gracious about it. You somehow got my home number and woke me from a deep sleep. I had no idea what I was saying yes to.
We were basically blackmailed, Your Honor. Judge Aldrich told us to accept the knockdown number or else. And the or else being that he would order a new trial, keep the case, and steer us into defeat.
You're talking about one of my most respected colleagues.
Who committed gross abuse of discretion. What he did not respect you, Your Honor, or the court. It was blackmail, and I am not overstating it.
You can substantiate this?
Yes. My co-counsel Lindsay Dole was present, as was opposing counsel.
Ugh. If you thought the judge was out of bounds, you should have asked the court reporter to step in.
He never would have said that on the record.
But you need a record in order for me to act, Miss Frutt. At minimum, you should have appealed the reduction. Instead, you agreed to the knockdown and you took the money.
My clients took it under duress.
Well, that was a big mistake. And you made it. Maybe that's what's eating you.
What's eating me is being blackmailed by a judge. What he did was corrupt.
I don't see that on any appellate record.
What would be my options?
You could move for a new trial, request that Judge Aldrich recuse himself.
But Judge Aldrich would be the one who would rule on those motions.
Correct?
Is there another option?
You could file a motion with the Circuit Court of Appeals to have him removed for bias.
That's what I want to do.
It would be your word against his. And these judges would be federal circuit court judges. Do you understand? He doesn't just get a jury of his peers here. He gets his friends.
That's what I want to do.
I'd think long and hard about that, Miss Rudd.
Well, now it sounds like you're threatening me.
No. I'm giving you some advice.
I want to file a formal complaint.
Richard, is this it? We're never talking again?
There's nothing really to talk about, Helen.
Would you at least give me 20 seconds? Look, I know this goes against your fiber, but sometimes the people we charge with crimes are innocent.
Scott Wallace is not innocent.
My point being, I think he is. I also believe a witness lied after you coached him. Richard, we're officers of the court. It has to mean something.
I understand that, Helen. I also understood you to be my friend. And you cut my legs out. You basically accused me in open court of being dishonest.
Taking it a little too personally.
Let me tell you something, Helen. I get called a lot of things. The defense attorneys call me the midget. The judges call me Little Napoleon. I take a lot of abuse. But I get through it every day because I also have a reputation for being good at what I do. And I have a reputation for being an honest person. That reputation is dear to me. And when a colleague, a friend, stands up and obliterates that reputation, it's personal.
Hey, Richard. Helen?
Jimmy.
Hey, I thought I could drive you to the hospital.
Hospital?
Rehab. I got you all set up. You can do it outpatient.
Well, I was gonna go see my aunt today.
You can see her after, Jennifer. You promised.
Okay.
What's up?
Mr. Belluti, please step aside. Jennifer Cole, you're under arrest.
What?
Arrest?
Please put your hands behind your back.
What the hell is going on, Susan?
Distribution of a controlled substance to a minor.
Distribution?
Distribution of what?
Don't say anything. What the hell are you talking about? Distributing to who?
The baby.
My baby?
You gotta be kidding.
You're smoking crack for 2 now.
What is she talking about? What are you doing? Jimmy!
You have the right
Jimmy!
to remain silent. Anything you say can and will be used against you in a court of law. You have the right to talk to a lawyer and have him present with you while you were being questioned.
Just calm down and hear me out.
I won't hear you out. This is so ridiculous. There's never been a case made for distributing to a fetus, and you know it.
Just because it's never been made before. She distributed cocaine to her baby through her bloodstream.
I'll be moving for sanctions on this, and I'll get them.
How sure are you she won't use again? Like tomorrow? She has a viable baby. If she hasn't done any damage yet, she might the next time. I'm just looking to get her off the street until the child is born.
I got her in rehab.
Yeah, voluntary outpatient. Come on.
You still can't arrest her.
Technically, I can make the case.
You're
Read the
deluding
statute,
yourself.
Jimmy.
There's no way
Delivering a
you
drug
can
to
win
a
this,
child,
Susan.
It could be blood
you
to blood.
can't win.
I can if you don't fight me.
You're asking me to conspire with you to keep her in jail?
1 month. Until the baby is born. I know you care for this woman.
I do, and I'm telling you, she'll go crazy inside. She needs help, not jail.
This is the only way she's gonna get help. If she walks, it'll be straight to the local crack house.
We don't know that.
Do you know what crack does to a baby? It cuts off the blood flow. oxygen, nutrients, seizures, heart attacks, brain damage. Let's plead this out. Inpatient rehab, no jail.
You're asking me to cop to a bogus charge.
I'm asking you to consider you really have 2 clients here.
Susan.
If she gets out, she'll OD, miscarry, who knows what'll happen. She trusts you, and you can help her.
It's a complete long shot. This is a very popular judge, and the other judges aren't likely to sanction him.
What about the settlement that we agreed to?
Well, if we undo it, hopefully we can get you more. In defeat, you keep what you have.
So what happens?
Well, we have a hearing scheduled for tomorrow at 3:30. There's nothing to lose.
Okay.
You filed a formal motion against Aldridge?
What's the problem?
The problem, Eleanor, is this is not something attorneys do. Why? Because the federal court is like a club as far as judges go. They have tenure. They stick together. And the only thing that will come out of this is this firm will be retaliated against.
Oh, please, what can they do to us?
What can they do to us? You just saw firsthand what they can do. They could cut damage awards, overturn verdicts, give lousy instructions, deny bail, cut fees. What can't they do? Not to mention they could put all our cases at the bottom of the docket and we'd never even get the trial. What you're doing here could hurt all our clients. At a minimum, this should have been the subject of a partnership meeting.
Well, I've had bad experiences with partnership meetings.
Snide isn't what I was looking for.
Bobby, I have a plan, okay? I was hoping to avoid the hearing against Aldridge.
How?
I have a meeting scheduled with the lawyers for the EPA. I think with just a threat of the knockdown number being thrown out, I can ship the number up a little.
Somehow I don't believe this is about chipping up a number.
I am only trying to help the client. This is not about vengeance.
I don't understand.
You plead guilty to distribution. They'll recommend straight probation for a year.
Probation.
So long as you get residential treatment.
I hate those places, Jimmy. All those freaky junkies and weirdos. It'd be like poison for the baby.
You need help, Jennifer. You got an addiction.
I do not. I can stop whenever.
Then why haven't you? 8 months pregnant. Why the hell haven't you?
I'll go to my aunt's house. There's this little room. It's like the perfect size. I got no curtains yet because they're either going to be blue or pink, you know?
Jennifer.
Rehab's no place for a baby. A baby should be at home. Please, Jimmy, what do I do?
They got a case here, and they're real serious. I think you ought to take the plea. It's the best thing for you.
You really can't make it go away?
No.
How long?
We're hoping next week.
No, you gotta push it up, Bobby. I can't take this place. I mean, they see me as some rich guy. I mean, I'm gonna be meeting up with the end of a broomstick in here. Yeah, you gotta get me out.
Scott.
I mean, minimum security, something, work release.
Scott.
I mean, I got money. Milken got out with money. I can pay.
He was in on securities fraud. You're in for murder.
Look, get me out!
We're trying to push up the appeal as soon as possible, Scott.
I'll get a new trial, right? I mean, the judge made all of those mistakes. I gotta get a new trial. Give me a brand new trial.
That's what we're hoping for.
So you gotta hurry, Bobby. See, I thought I was okay, but I'm feeling maybe I'm not. Just hurry, okay?
Do you expect us to laugh?
No, I don't expect that, Mr. Myers. We have a hearing set up for tomorrow. These are your subpoenas to appear as witnesses. If you refuse...
And you think if you call us as witnesses, we'll testify that Judge Aldrich was guilty of blackmail?
I think if called as a witness, you will give truthful testimony, yes. And we all know what happened in that room.
Miss Frutt, I truly do admire your fortitude. But if you have any notion that we will compromise our client's interests...
You wouldn't be lawyers in this proceeding. You'd be witnesses.
You're insane.
Look, we're not really here trying to secure you as witnesses.
Why are you here?
If we're successful at overturning Judge Aldrich, that $72 million verdict could be reinstated. You have to be concerned about that.
We're not.
Do you really want to risk it?
The odds of that panel overturning Judge Aldrich is...
Do you want to risk it? $72 million.
Why don't you get to the punchline?
For $6 million, we'll drop the complaint against Aldrich.
Once again, I must ask, do you expect us to laugh?
You won't be laughing if the 72 comes back.
I think we'll run that risk. Anything else?
The hearing is scheduled for tomorrow at 3:30. You've received your summons.
Yes, and between now and then, we'll be sure to go over our testimony.
You really are an ass. You know that?
Tell a friend.
He's extremely erratic. He's going on and on about buying his way out of jail.
Is he talking about Fiji again?
No, but
I just got off with the clerk from the appellate court. They can hear you next Tuesday.
schedule it. Can you have the brief ready?
Yeah, it'll be done.
What time's the hearing?
3:30.
I'm gonna go see Aldrich now.
What? Why?
I'm gonna try the velvet glove first.
You really think this guy's gonna listen to you after you file a motion against him?
Docket number 3542, Commonwealth versus Jennifer Cole.
Susan Alexander for the Commonwealth, Your Honor.
James Berluti for the defendant, waive reading. We're entering a plea of guilty pursuant to an agreement.
Let's hear it.
1 year in the House of Corrections, suspended. 1 year probation, as long as she enters a detox center today. Upon release, she immediately goes to a halfway house, then to a sober facility for the term of her probation.
Just a second. This is the same offense as yesterday?
No, Your Honor, this has nothing to do with the search. The defendant was seen by witnesses ingesting cocaine.
The charge is distribution.
She is in her 8th month of pregnancy. She ingested cocaine, distributing the drug to her unborn child.
Come again?
The distribution was to her fetus.
What's going on? We're fine, don't worry.
Mr. Berluti.
Yes, Your Honor.
You have fully explained to your client the nature of these charges?
Yes, Your Honor. Miss Cole understands the charges against her.
Do you? Miss Cole, did Mr. Berluti explain that it's extremely unorthodox for a pregnant woman to be charged with this crime?
Sorry?
What did your lawyer say about the case against you?
I don't know. He said I should take the plea.
Did he say why?
Your Honor...
I am addressing the defendant. Did he say why you should take the plea?
He said we probably wouldn't win this.
Mr. Berluti, Ms. Alexander, Chambers. I have never seen this law enforced against pregnant women.
That doesn't mean it can't be.
I'm not sure you're right about that. But even if you are, I see no basis for a defense attorney to surrender. What did you two do? Decide on a punishment? Then flip through the general laws in search of a crime?
I don't believe you have the right to change a plea agreement.
I certainly have the right to reject one.
On what grounds?
Due process, unethical behavior, lack of legal basis, collusion. Take your pick. What's our role today, Mr. Berluti? Lawyer or mother?
I advised my client. The fact that you may disagree with my advice does not make me unethical.
You took an oath to zealously represent your client's legal interests, counsel. Getting her into rehab doesn't qualify. Did you inform her that this case would likely not make
I told her I couldn't be sure.
Mr. Berluti, you might as well answer my question, because next I will be asking her. Did your client, when agreeing to this plea, fully appreciate that she would probably not be convicted of the crime with which she was charged?
My client is a crackhead. She can't even fully appreciate that she's killing her baby.
The plea is rejected. I'm reporting both of you to the state bar. Get out.
Ever see a cocaine baby, Your Honor?
Mr. Berluti, you are an officer of the court who is one word away from contempt.
We really don't want to go after you.
I'm touched by that.
Your Honor, we have great respect for both you and your position. But our feeling is you did cross a line here.
Let me tell you something, Miss Dole. I was at that trial every day. There was no case. You people should be laughing to get $400,000.
But that's an evaluation of the merits, which is the jury's function.
The jury blew it.
Okay. But to go from 72 million to 400, I mean, if I could prevail upon you to revise the knockdown number, I could certainly prevail upon the client to pull back on their complaint.
The client isn't pushing this. Eleanor Frutt is the driving force here. Don't you think I know that? Well, here's something she should know. I have life tenure. I will be here a long, long time with a vivid memory, and you people will not intimidate me.
We're not looking to do that.
Tell Miss Frutt I'm issuing a gag order in connection with this case. If she says one word to the press, she's in contempt. And if she snorts out a single negative utterance about me to anybody, I will refer her to the Federal Disciplinary Panel for violating the court rules for disparaging a judge. If she wants a fight, she's got one. You go tell her that, Ms. Dole.
Richard, did you have the Wallace file removed from my office?
They're working on an appeal, Helen. Certainly you don't expect me handling it.
Why didn't you just ask for the file?
I couldn't presume your cooperation. For all I know, you might make copies of our work product and hand them to the defendant.
Look, I think you know in your head what I did wasn't personal, and what you're doing now is.
You act on your principles, Helen. I'll act on mine.
My principle was justice, Richard. Yours is politics.
Politics?
I know what's going on, Richard. I still have ears. Suddenly, I'm a pariah in the department, and you're choosing to distance yourself. That's fine. But let's not forget, your career was hanging by a thread a few months ago, and I'm the one who stood with you and behind you. Now, the idea that the association with me could be detrimental, you run. You're a hypocrite and a coward. Please do take that personally.
So you lied to me.
I didn't lie, but
I stand a good chance of getting this case dismissed.
yes,
You lied to me.
Jennifer. I'm just trying to keep you safe until the baby is born. You're still using, for God's sake.
So what happens now?
We go back in before Judge Spindle this afternoon. She might bond you over for trial. She might kick the case, depending on how convincing the DA is.
I want another lawyer.
If you want me to beat it, I'll try.
I want another lawyer. Can I get a public defender?
I'm sure you could,
Then
but...
that's what I want. You're fired, Jimmy. Please leave.
Jennifer.
You're fired.
You're gonna wind up dead or killing your baby. Guard.
And he said if we opted for a new trial, he would probably remit the next award to $75,000. He was clearly threatening to punish us if we exercised our legal rights.
Ms. Frutt, judges try to steer lawyers all the time.
This was much more than steering. It was a threat.
May I respond to that?
Please do.
If I was guilty of poor judgment, it was in allowing any award. For me, 75 was too high. But when you're sitting in front of sympathetic parents who've gone through the ordeal of a long trial in the wake of a jury verdict, I didn't want them to walk away empty-handed. That's why I gave them the 135. I let Ms. Frutt know she shouldn't bank on my continued sense of charity.
You chipped a $72 million award down to $400,000 out of a sense of charity?
I allowed you to keep the 400 on a claim that was really worth nothing.
We've certainly allowed murder charges to stand against people who caused the death of unborn viable fetuses.
But those are third parties, not the mother. Moreover, for drug distribution, you have to establish a specific intent, and there's been no showing of that.
Specific intent can be inferred.
Are you suggesting she intended to poison the fetus with cocaine?
All I'm suggesting is that if you commit an act that causes a result that is not only foreseeable, but in fact unavoidable, intent can be inferred.
I'm sorry, Ms. Alexander, but I have to consider the legislative intent. And there is no evidence that the drug distribution laws were ever meant to apply to pregnant mothers under this fact pattern.
There's no evidence to disprove the legislative.
Ambiguity cuts in favor of the defendant.
All I'm asking is that you bind her over. Let's just hold her
I
until...
can't do that.
In the alternative, I'd like to continue this matter. Allow me to do further research.
Denied. The charges against Ms. Cole are dismissed. This time I am doing so with prejudice. The defendant is free to go. We are adjourned.
Thanks. Thanks a lot.
Let's go.
Go where?
Rehab. Everything's set up.
I'm not going anywhere with you, Jimmy.
Jennifer, you have a problem.
Whatever my problems are, I'm not about to come to you with them. Bye.
You people hardly have an unblemished track record, Miss Frutt. In fact, I might go so far as to say you have a penchant for deceit.
Whatever you may think of our penchants, we have always played by the rules. He didn't. It was cowboy justice.
I have to say, as I see the facts, most judges wouldn't have let this even go to trial.
Your Honor, we were in that room. We heard what he said and the tenor of how he said it. It was blackmail. He took away our Seventh Amendment right to a jury trial, and then he threatened us if we dared appeal. That's not the way it's supposed to work.
I know Judge Aldrich. I've known him for 20 years. I'd sooner take his word than that of a few criminal defense attorneys who moonlight with contingent fee cases.
I object to that.
Do you have anything else, counsel?
Yes, Your Honor. I'd like to call Mitchell Kravitz.
What are you doing?
I have no idea.
Mr. Kravitz, please come forward and be sworn in.
Please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be
What are you
seated.
gonna ask him?
I don't know. You ask him something.
Okay, Miss Frutt, you may question Mr. Kravitz.
Sir, you were in Judge Aldrich's chambers the day in question for the transaction in question in your capacity as defense counsel for the Environmental Protection Agency. True?
True.
You've been sitting here listening to my version of what happened and to the one offered by Judge Aldrich. Do you have an opinion as to which version is more accurate?
Given that I participated in this transaction as an attorney, I don't feel it's appropriate for me to also bear witness on the events.
We have had a judge bearing witness, sir. It's okay if you do so as well.
Your Honor, I represent clients. I have a duty to
This
those
is a
clients.
hearing about the conduct of the officers of the court.
It does not concern the interests of clients.
Certainly, if it affects the interests of clients, I can't be compelled to
I want
testify.
to know what went on in that room, sir. You heard Judge Aldrich a short time ago. We have all been listening ad nauseum to Miss Frutt. Whose testimony today more accurately reflects what went on in that room?
The court has asked you a question, Mr. Kravitz.
I believe the truth lies somewhere in the middle.
On whose side of the middle does the truth lie?
Miss Frutt.
Oh my God.
You believe Judge Aldrich was guilty of judicial misconduct? I asked you a question, counsel. Do you believe Judge Aldrich was guilty of judicial misconduct?
I think he conducted a fair trial. But what happened in his chambers after the verdict, while it wasn't blatant blackmail, it was definitely coercion.
May I respond to that?
Go ahead.
I strongly disagree with Mr. Kravitz's characterization. Let's remember, he was in the throes of being smacked with a $72 million judgment. His career was probably flashing before his eyes.
I resent that.
I have the floor now, counsel. His powers of observation may have been on tilt.
But surely not biased. Not against a judge ruling in his favor.
Let me say also, a judge every single day exercises some coercion. Our dockets are jammed beyond repair with claims that have no real merit. This was one such claim. We push, steer, bend, influence, and yes, coerce. We do it every day. If we didn't, God help the mess, not to mention the injustice. The line is a gray one. I submit to you I did not cross it here. The facts underlying this case did not justify a $72 million verdict. I was there at the trial. I heard the evidence. This panel did not. There was no abuse of my discretion. The knockdown number was fair.
The knockdown number is knocked out. The award of $72 million is reinstated. Defense is free to bring a new motion to remit once the case has been reassigned. We are adjourned.
I'm afraid to celebrate.
Very wise. The 72 will still get chopped down. We're gonna do some research and come up with a number to try and settle.
Okay. Wow.
Yeah.
Josh.
Jimmy. I shouldn't be talking to you. Doctor, patient?
Yeah.
Partial placental abruption. Placental lining started to come loose from the uterine wall.
Coke.
She started bleeding, had enough sense to call EMS, went into shock.
The baby?
We delivered. Little girl. 3.5 pounds.
You all right?
It's too early to tell. She lost oxygen because of the abruption. We're gonna do a cranial ultrasound, check for a stroke. And there was cocaine in her body, some agitation, maybe withdrawal. We had to notify social services.
Sorry, Jimmy.
You just rest.
They won't let me see her.
Later.
Is she okay?
We don't know yet. The doctors are hoping.
They're gonna take her away from me, won't they?
It's too soon to know anything, Jennifer. Just try to get some rest.
Don't let them take her away. Okay.
Okay.
Previously on the practice.
We have one last pretrial where I'll try to suppress your statement. Scott, if I'm unsuccessful...
No, I'm not taking manslaughter, Bobby. Please don't ask me that again!
He's gonna walk?
I'm not saying that, but...
But what? He killed my sister. Don't tell me now that he's...
Mr. Barrett, as we have explained from the start, our case is hugely circumstantial.
You knew your sister, sir. There is no way she would ever take her own life. Not in any circumstance. She was murdered. If you know it. She did not commit suicide. You absolutely know it.
She said that if she turned up missing, that I should call the police, because Scott probably did something to her.
Objection!
You want me to sign this? An affidavit saying I coached a witness to lie?
He made that stuff up about his sister being afraid.
Helen, I told him what his testimony needed to accomplish. I never said lie.
I'm convinced that Kyle Barrett lied on the stand after being coached by the prosecution.
I don't think Mr. Bay crossed the line. I see no evidence that he solicited perjury. The conviction, therefore, stands.
Look, I'll get a new trial, right? I mean, the judge made all of those mistakes. I gotta get a new trial.
That's what we're hoping for.
I thought I was okay, but I'm feeling maybe I'm not. Just hurry.
Two years. That's it?
Yes. It's a decent plea for us. If he gets convicted, the most he'd serve is probably 3.
But I could have died, Helen.
I understand, but like you said, you didn't think he was really trying to kill you.
But he tried to hurt me.
Which is why he's about to go on trial. I'll get him, Margaret. But if we can get the plea, You don't want to be put through this. I know your husband's lawyers. They're tough.
3 years.
I am not pleading guilty.
Look, this is your wife saying you pushed her down a flight of stairs.
I didn't touch her.
The problem is victims of domestic violence can look very sympathetic.
She is not a victim.
Well, they'll make her look like one. And the jury is going to want to know, why would she lie about this?
I would like to know myself.
Robert.
What about my daughter? If I plead guilty to a crime like this, then I'll lose custody of her.
Well, that isn't necessarily true. You could get custody.
No, I didn't do it. I didn't throw my wife down a flight of stairs, and I won't say that I did. You know, I don't care what my odds are. No.
Can I have your attention, everybody? I have very exciting news. Now, it's kind of private, but I've been keeping it in for like 2 months now, and I can't anymore. I'm sorry.
What?
Well, 2 months ago, now keep in mind it is so not like me to go through waste cans, but it was a dull day, and I was in the ladies' room. Anyways, I found this pregnancy test thing, and it was positive. Now, I know it could have been anybody on this floor, but I still had a feeling. Then yesterday, a book came. And I opened it, thinking it was just office supplies, books, usually library things. Unfortunately, I threw away who it was addressed to, and then the trash guy came and picked it up, and, well, whatever. What to expect when you're expecting? Somebody hears Pragos. Lindsay?
I didn't order that thing.
Oh, come on. I thought I saw a tummy.
I did not order that thing.
Lindsay, we might as well tell him.
That's great.
Thank you, Lucy, for your exciting news.
Well, I couldn't keep it from the family.
How far along?
4 months.
Who's the father?
You're funny today.
Congratulations.
Where are you at, ma'am? Ma'am?
830 Brayson! You have to hurry!
Okay, stay on the line. Just tell me what's happening. What are you doing?
My husband! 830!
What the hell are you doing? Margaret! Ma'am, are you there? Can you get back on the phone, ma'am? Hello? What's happening, ma'am? Hello?
830 Brayson. Are you familiar with that address?
Yes. After getting the radio run, I responded to that location.
And what did you find?
The front door was open. When we got inside, we found the defendant at the base of a stairwell in the foyer area. Mrs. Wakefield was lying face up wearing a nightgown, and she appeared to be unconscious. The defendant was sitting next to her, holding her head from behind.
Was there anybody else in the house?
The defendant's 9-year-old daughter. She said she was in her room and didn't see anything.
Could you describe the defendant's demeanor when you spoke to him?
He was very upset. Right away, I could smell alcohol in his breath and his eyes. They were very glassy.
What did you do next?
I called for an ambulance, and we took Mrs. Wakefield to Mass General.
Could you describe her condition?
At first, she was still unconscious, but on the way there, she started to come to. That's when she told me that her husband had pushed her.
Just to be clear, officer, could you describe Mrs. Wakefield's exact words?
He pushed me. Robert pushed me.
You said my client was upset.
Yes.
He wasn't violent.
No.
And when you got there, you saw him sitting with his wife, holding her head in his hands.
Yes.
So you cannot exclude the possibility that Mrs. Wakefield tripped on her own nightgown.
Can I positively exclude it? No, but I...
Thank you, officer. When Mrs. Wakefield was taken to the hospital, my client went with her, right?
He met us there, yeah.
And did you permit Mr. Wakefield to visit his own wife?
At that point, we didn't even know what we had.
Really? So even after Mrs. Wakefield's big statement in the ambulance, you still weren't sure a crime had been committed?
We were investigating.
You weren't sure about what she told you?
We had no reason to doubt her.
But the man she accused of pushing her, you allowed him to visit her, didn't you?
Yes.
What do you mean, spots?
I mean spots. It's worse when I look at the light, but even when I don't, I still see spots. They're big, and then they shrink, and then When I blink, they come back. Not always, but I mean, sometimes. Sometimes I see him.
And you said they had the optometrist examine him?
He's a hack. I mean, how many kids do you know went to med school so that they could examine prisoners? I mean, the doctors in this place are all unemployable hacks. Is it fun?
Is what fun?
Well, I would think it'd be fun. You know, you must dream about big cases. And this one, a murder, your friend on the hook. I mean, I would think that this has all the stakes that any lawyer could ever wish for. And if you're not having fun now, Bobby, I mean, then what's the point? You know?
Scott, we're going to have you meet with a psychiatrist.
I was convicted, for God's sake. What, you want to have me declared incompetent to stand appeal? Oh, I mean, that's smart. Why don't you examine my eyes while you're at it? Do I get to go?
Go where?
He's losing it.
We gotta get him the hell out of here.
Margaret? What's wrong?
I don't think Robert intended to push me down the stairs.
I beg your pardon?
I've been replaying this over and over again.
Have you been talking to him?
We have thought of reconciling. But this is the truth. I made a mistake.
Margaret, don't you dare do this.
Helen, at the time, I didn't know what to think. One minute we're fighting, the next I wake up in a hospital. Police officers asking me questions. You know, I was angry. I think I convinced myself at the time that he did it on purpose, but he didn't. And I'm dropping the charges.
First of all, you don't get to drop the charges. Only the district attorney can do that.
But it's my choice whether to continue.
Actually, no, it's not. You chose to call 911. Now I make those decisions.
I'm not testifying, Helen.
Then I'll get a material witness order and have you arrested.
If you try to force me, I'll tell the jury I fell. This was an accident.
Oh, Margaret, I know you think you have no life without this man, but trust me.
I'm not some weak victim here. Look, we've had a complicated, volatile relationship. If you want to prosecute me for false arrest or whatever, I'll own that. But the man didn't push me down the stairs.
What happened?
My victim just recanted. That's why I prefer murders. When they're dead, they can't change their stories. What do you want?
I came to apologize. I have been a little influenced by politics of late. You were there for me when my job was in peril, and I want you to know I'm here for you now.
Is my job in peril?
Helen, they've stuck you with domestic violence. What does that tell you?
They. They being Kate Brunner.
Well, that's... She carries a lot of power. I'm told you're supplying Bobby Donnell with an affidavit.
Not that you suborned perjury, only that I thought the witness was coached and that he committed perjury.
If I can give you a little advice, I wouldn't give him that statement.
Is that why you're here, Richard? To reach out and gag a friend?
No, it really doesn't affect me.
It does your case, and therefore you with Kate Brunner. You win, she likes you. You lose, she doesn't.
And if I lose, you will get the brunt of the blame, not me.
I already gave Bobby the affidavit. But thanks for stopping by, Richard. It's been good to catch up.
You working late?
The Wallace appeal is tomorrow. Are you feeling okay?
Fine.
I'm glad it's out. It was hard for me to keep it a secret.
Bobby, I didn't take the pregnancy test here. Did you order that book?
Me? No.
That little witch tricked us. Either that or somebody else is pregnant.
You okay, Beck?
Oh, sure.
What you thinking about?
Just the case.
Miss Washington? Can I speak to you?
Well, I represent your husband.
Yes, I know. I've decided not to testify.
Oh. Well.
Actually, I do want to testify. But for Robert.
I'm not sure I understand.
Your client is innocent.
You got a problem. He's about 2 weeks away from Bridgewater. He's suffering from severe clinical depression. He needs to be hospitalized right now.
We're due in court.
Bobby, this man is not going to court. He's in the middle of what's called a situational mental breakdown, most likely caused by twin positional traumas, the death of his wife and the conviction. The spots, the inability to sleep. The man is on the verge of a psychotic breakdown. He needs to be transferred to a mental facility right now.
Eugene, go to Wolf, file a motion that he be transferred to the hospital jail ward. I'll handle the appeals court myself.
I'll need your affidavit. Can you agree to supervise at the hospital?
Absolutely. You've got to get him out of prison.
Let's go.
He had me by the shoulders. I can remember his face being right there in front of me. I had never heard him scream like that.
What were you fighting about?
The same thing as always. He wouldn't stop drinking. It was getting worse since the wedding.
Did you tell him you were worried?
I tried. But when Robert's like that, you can't tell him anything.
What was he saying?
It was my fault. He had to drink because I was making him miserable. He was yelling and shaking me. That's when I got scared. I waited till he left the room and called 911.
Tell the jury why you called the police.
I never wanted to have him arrested. I thought they could just get him out of the house. Hold him, maybe, until he was sober again.
But then he heard you on the phone.
He came up behind me and ripped the phone out of my hand. That's why I was screaming on the tape. I was scared, so I ran. When I got to the stairs, I was going too fast. All I remember is falling and waking up at the hospital.
Mrs. Wakefield, I want to be clear. Did Robert push you down those stairs?
No. We were fighting, but he didn't hurt me. I tripped and I fell.
But that's not what you told the police.
I was angry. They were trying to get me to say what they wanted, and I wanted to punish him.
We were at the top of the staircase. Robert had me by the hair. I begged him to let me go, and then he pushed me from behind. Isn't that what you said in the hospital?
I didn't really have time to think about things.
Have you and your husband talked about reconciling?
Yes.
When did you have these talks?
A few days ago.
Look at your face, Margaret.
Look, I'm not saying that I didn't fall down the stairs. I'm not saying that it didn't happen as a result of an argument and scuffle with Robert. What I am finally admitting to...
You've answered my question.
No, I haven't.
Ask that the witness be instructed.
You are trying to make it seem like he's controlling me.
The witness may answer the question.
What I am finally admitting to is that he didn't intend for me to fall. I know that disturbs your case, but like it or not, it's the truth.
I would like to focus the court's attention on our first issue for appeal, which is the trial court's refusal to conduct an evidentiary hearing concerning the charge of perjury by a material witness and the prosecution's role in suborning that perjury. Attached to our supplemental brief is the sworn affidavit of District Attorney Helen Gamble, who was present when Mr. Bay encouraged the witness, Kyle Barrett,
It alleges he coached the witness, but doesn't go so far as to state he suborned perjury.
It says he supplied testimony which was new and different from any prior statement given by this witness. That, to me, implies perjury. And a reading of Miss Gamble's affidavit reveals that she, too, drew that inference.
Mr. Bay, I assume you take issue with this allegation.
I'm offended by it. I certainly expressed to the witness the need for his testimony to be compelling. I never remotely asked him to lie.
What about the idea that you supplied the testimony?
I gave him a list of points we needed to cover. I told him what was most relevant, what needed to be emphasized. The idea that I encouraged false testimony is preposterous. It's a desperate ploy by a defense team that's even arguing its own inadequacy, if you look at paragraph 6.
I haven't got to that yet.
Your Honors, this is the catch-all inadequacy of counsel appeal that's typically thrown out there when the defendants have little else to go on. The fact remains, Scott Wallace is an educated man. He participated in his defense fully. This was a strategic decision to which he relented. It does not rise to a denial of his right to testify.
It's unfair surprise.
I didn't know about it myself. I just uncovered.
That doesn't matter. At this point in the trial...
Look, I'll give you time if you want discovery.
I don't want time.
Hold on. These are records of her injuries?
No, Your Honor. His previous wife. There are also medical records of 3 injuries to the daughter. A broken arm, a shoulder bruise, and a laceration.
Over a period of...
11 years total.
First of all, there is no evidence or suggestion that my client caused these injuries.
Was Mr. Wakefield ever accused of any abuse?
No, but with this pattern, he probably should have been.
Do you have any evidence that he caused them?
No, but...
Denied. You know better than that.
Your Honor.
Out you go. I'll see you back in court.
Did you hit your first wife?
What?
They dug up hospital reports, and someone Jennifer, too.
No, they're saying that I hit them?
Well, luckily, they don't get to say it. But my question is, did you?
Of course not. Rebecca.
How'd she get her injuries?
What injuries?
Bruises, cuts. Jennifer had a broken arm.
She fell off of her bike. Joanne, she rode horses. She jumped. She had a couple of accidents, maybe. What the hell is this? Is this what happens now? They start manufacturing things?
Seems like a lot of accidents, Robert.
Hey, I've had my share of yelling arguments. I've even grabbed, from time to time, both Joanne and Margaret, but I have never, ever hit a woman. And my daughter...
I don't think it's wise for you to testify. I suggest we rest and go to closing.
And why is that?
Because Helen Gamble could backdoor that other stuff on impeachment and it wouldn't look good. Trust me.
Do I need another lawyer here?
I'll finish.
I don't want you finishing unless you believe me. Do I need a new lawyer?
I'll finish.
I'm telling you, Eleanor, I know this woman. She's covering for him. I know her.
At the risk of getting my head bitten off, ground into wheat germ and sprinkled on your cereal, I know you.
What's that supposed to mean?
It means you are under a lot of pressure at work. Have you considered the possibility that you need this conviction so badly you are willing to chase one even in the absence of a crime?
Look, after what I did on the Wallace case, how could you even say that to me?
I believe you believe he's guilty. My question is, do you need to believe it? The only eyewitness is the victim, and she says there was no crime.
Is she the only eyewitness? Jennifer? Hi. Are you Jennifer Wakefield?
Who are you?
My name's Helen Gamble. I'm a district attorney. Could I talk to you for a second?
I know who you are.
Donald Young... whatever. Yeah, he's right here. It's the clerk's office about the Wallace appeal.
Hello. Yes. Today? Thank you.
What?
They ordered a full hearing on the perjury issue. We go back into Judge Wolf today. That's our best grounds, Eugene. We have a shot.
I don't believe it.
We're back in this.
Well, let's not get carried away.
Eugene, it's our best grounds. We're gonna get him out.
Bobby, we can't get Scott's hopes up. Not yet.
They turned us down on 3 issues. But on the perjury, we get a full hearing.
And this is good?
Well, we were hoping they'd order a new trial outright. We didn't get that. But with a hearing, if the judge determines that the brother did commit perjury, then we get a new trial. Unfortunately, we go before the same judge we had at trial.
Wolf?
Yes, but...
They said no toast! No toast.
Scott, you need to rest. The doctor says that you're suffering from clinical depression. Karen dying, the conviction. You need to rest. Take your medication, and we'll do what we need to do.
Spots are going away. I'm doing better, Bobby. Yeah, I'm not seeing the spots.
This is great.
You'll come back and see me after the hearing?
I promise.
She is a witness. I have a right to question any witness.
I filed my appearance with the court indicating I represent the entire family.
Which is a potential conflict of interest.
You take that up here, not on a playground.
You went to the school?
Yes.
What the hell is wrong with you?
What's wrong is I think this girl may have seen or heard something that night.
Then your course of action was to get a material witness warrant.
Oh, Your Honor, under the circumstances...
There are rules barring contact with represented parties that especially apply to prosecutors, Ms. Gamble. She's 9 years old.
I believe the witness is under the control of the defendant.
You have been running about, making accusation after accusation with nothing to support it.
That's why I went to ask questions.
Well, you went about it the wrong way. You are restrained from going near the girl. You're lucky I don't report you to the bar.
Your Honor, if...
That is all.
Do I have to do anything?
No, I promise. We just want you to be there. It would be good for the jury to see you all as a family, that's all.
Okay.
Jenny, could you go out for a second? I'd like to talk to Miss Washington.
I'll take her.
Thank you.
Come on, hon.
Is this really necessary?
I wouldn't ask for it if I didn't need to. We stand a very good chance of an acquittal here. Why risk it?
The risk is her being traumatized. She's got to sit and listen to accusations that her father threw her stepmother down the stairs.
Again, I'm trying to avoid a conviction.
All right, Mr. Donnell. Call your first witness.
The defense calls Helen Gamble.
Offer of proof.
Ms. Gamble was there in the room with Barrett and Mr. Bay. She was the lead DA.
What's she going to say that's not in her affidavit?
Well, she will confirm all the allegations made in her affidavit.
She doesn't need to. I've heard them. Call your next witness.
What about the Commonwealth's right to cross-examine this witness?
Mr. Bay?
I think the court can take judicial notice we dispute Miss Gamble's claims.
The Court of Appeals ordered a full evidentiary hearing on this issue.
I will enter her affidavit into evidence. Call your next witness, please.
I object to this.
If you have any other witnesses, you better call them. Otherwise, this evidentiary hearing is over.
The defense objects to the court acting out of ego. The defense wants it noted for the record that the trial court judge is angered by the fact that the appeals court ruled he was in error. And the defense wants its objection noted for the record that the trial court judge is not complying with the order of the appeals court.
I will repeat. Call your next witness or the hearing is over.
My next witness, Kyle Barrett, hasn't arrived yet.
We'll adjourn until he does. 1 hour.
So we have a crime where the victim says it didn't happen. Now, did she once claim it did? Yes. But as she explained, she was confused and angry, and she lashed out. And all those statements came when she was emotionally unsteady, as she told you. But now she's admitting the truth. It never happened. All those prior statements she made up. We don't just have reasonable doubt as to his guilt here. We have proof of his innocence. She finally let go of her rage and let the truth come out. If only we could get a zealous district attorney to do the same.
Yes, that's the only reason we're here. Because I'm an angry, overzealous district attorney who cannot let go of her rage. Do you really believe that? Nothing to do with the fact that an unconscious woman was rushed to the hospital. Let's just forget the 911 call where the victim was screaming while the defendant pursued her. This isn't the day after, ladies and gentlemen. It's not the week after. These charges were filed 6 months ago. Margaret Wakefield has stuck to her story since last spring. It's only after she and her husband talked 2 days ago about reconciling that she suddenly rises up and says, "Gee, I think I was mistaken. It must have been an accident." Do you really believe that? I'm sure Margaret Wakefield is a little frightened. Her husband, Robert, supported her. He's the father of her He's the father of her stepdaughter. She's suddenly faced with losing everything, and she thinks, maybe we can work it out. They talk about reconciling, and suddenly, poof, it's an accident. He threw her down the stairs. Can't be erased. Even at the victim's own request. It happened. And it will probably happen again. You heard that tape. You heard those statements to the police, to the hospital. Robert did it. Robert pushed me. She can say whatever she wants to now. But she didn't take an oath to uphold the law. The 12 of you did.
Could you please state your name and address for the record, sir?
Kyle Barrett, 1505 North Street, Walpole, Massachusetts.
Mr. Barrett, you are the brother of Karen Wallace, is that correct?
Was the brother, until your client killed her.
Mr. Barrett, in preparation for your testimony at Scott Wallace's trial, you had a meeting with Richard Bay and Helen Gamble, did you not?
On the advice of counsel, I'm exercising my Fifth Amendment right not to answer your question.
Excuse me?
Your Honor, I'm Matthew Stone, Mr. Barrett's attorney. Though my client maintains his complete innocence with respect to any allegation of perjury, given Helen Gamble's beliefs, I have to advise him not to answer these questions.
Your client is not on trial here, Mr. Stone.
Understood, but with the possibility that charges could file, he has a Fifth Amendment right, and it would be foolish for him not to exercise it.
You have to grant him immunity. It's the only way you can force him.
You can forget that. If this man committed perjury in a first-degree murder trial, I am not going to offer up immunity like a stick of gum.
I have to be allowed to question him.
I can't force him to waive his Fifth Amendment right.
We're being denied our evidentiary hearing.
Hey, why don't you supply me with some precedent where I get to take away his right not to incriminate himself, and I'll be glad to accommodate you. Is it your client's intent to take the Fifth on every question he's asked?
Yes, Your Honor.
Everybody get out. I'm going to take 10 minutes to think about this, then we'll reconvene. Out!
Thought you quit.
I'm not supposed to talk to you, Helen.
You seem to be doing a lot of things you're not supposed to do, Margaret. You know, I couldn't figure it out. Then finally it hit me. You're not going back to Robert because you love him. You're doing it to protect Jennifer because it's the only way you can.
I don't know what you're talking about.
Yes, you do.
No, I don't.
Reason you're so horrified that he'd only get 3 years in prison is because when he got out, Jennifer would only be 12, and you're worried he'd get custody again. Faced with that, you decide to reconcile so you can always be there to protect her. Margaret, he might not get custody under the law.
I know the presumption, but there's a good chance he would. And then what?
What happens the next time he pushes you down the stairs?
Honey? Everything okay?
Everything's just swell, Mr. Wakefield.
Come on.
All rise.
Be seated.
I have been ordered by the Court of Appeals to conduct a full hearing into this perjury business. That hearing has been thwarted by the primary witness exercising his Fifth Amendment right not to testify. The conviction of Scott Wallace is hereby set aside. It is the order of this court that he be granted a new trial. Adjourned.
We fully intend to retry him. This man committed murder, and the district attorney's office will pursue him until his home in prison becomes permanent.
Were you surprised by the ruling?
Shocked is more like it, and outraged. Judge Wolf certainly acted within his discretion, but the reality here is a killer could get back on the street. And I find that horrifying.
When will Helen Gamble's role be in the next trial?
I will be prosecuting. I'll be in charge.
Look at him. Every time he loses, he shrinks an inch.
Amazing. They do it all over again now.
It's amazing. Is it exciting?
New trials?
Being pregnant.
Oh. Yeah, it's really amazing. You think Rebecca is?
I doubt it.
Well, the book and the tests, it's kind of an elaborate scam, even for Lucy.
Yeah, but between you and me, I don't think Rebecca's really pregnant. And I don't think Lucy's playing any trick.
Then how did that book get here?
I ordered it.
Why?
Because I'm pregnant.
So I'm not convicted anymore. I mean, I'm not convicted.
No. The verdict is out.
Do we do it again?
We do it all over again. And this time, we're gonna win.
Okay. These drugs make me weak.
They're to help you rest. You just get better now, okay, buddy?
Okay.
You get better. Next time, we win. We win.
The defendant will please rise. Madam Foreperson, the jury has reached its unanimous verdict.
We have, Your Honor.
What say you?
Commonwealth versus Robert Wakefield. On the charge of assault and battery with intent to cause serious physical injury, we find the defendant, Robert Wakefield, not guilty.
Members of the jury, this completes your service. You're dismissed with the thanks of the court. The defendant is free to go. This matter is adjourned.
Thank you. Thank you, Rebecca. Thank you so much.
Congratulations.
Previously on the practice.
We find the defendant, Scott Wallace, guilty.
Yeah, you gotta get me out.
Scott.
Get me out!
You got a problem. The man is on the verge of a psychotic breakdown. He needs to be transferred to a mental facility right now.
We were hoping they'd order a new trial outright. We didn't get that, but with a hearing, if the judge determines that the brother did commit perjury, then we get a new trial. Mr. Barrett, you had a meeting with Richard Bay and Helen Gamble, did you not?
On the advice of counsel, I'm exercising my Fifth Amendment right not to answer your question.
I have been ordered to conduct a full hearing into this perjury business. That hearing has been thwarted by the primary witness exercising his Fifth Amendment right. The conviction of Scott Wallace is hereby set aside. It is the order of this court that he be granted a new trial.
What to expect when you're expecting? Somebody here's Pregos.
Lindsay, we might as well tell him.
Did you order that book?
Me? No.
That little witch tricked us. Either that or somebody else is pregnant. How did that book get here?
I ordered it. I want to keep it a secret until I'm sure everything's fine.
Who's the father?
I'm gonna be a single parent.
It starts today.
It's a simple trial, one prosecution witness.
You can't put me on a case and expect that I'm...
Actually, I can, Eugene. Perks of the road. Now, he fired his last lawyer, just like the two before that, and I have an obligation to make sure he gets a fair trial with adequate representation.
Well, if you're so concerned with fairness, how about giving me time to fully prepare?
Well, I'm not that concerned. Let me be frank. The defendant is world-class scum. I'm sure he's guilty of the crime.
Well, I'm glad you have an open mind.
Oh, please. A mind is like a wound. If it's too open, you get an infection. Now, he is stalling by firing one attorney after another. I am not going to let him get away with it anymore.
Why me?
Because you're as good as it gets when it comes to criminal law. And I don't want to give this bastard a shot of appeal on inadequacy of counsel. So you will do it. Helen Gamble will be the DA. We all know how jolly she can be. See you in there. Go meet your lovely wife-murdering client.
I didn't do it. The cop just wanted to get his picture in the paper and credit for a big collar. I wasn't even there that night.
You lived there.
But I wasn't there that night. Look, did her and I have a fight? Yeah. Did I shoot her? No. They got one lousy witness, man. Eyewitness evidence is easy to shake, Mr. Young. It was dark. I was moving fast. No way he got a good, clear look.
So if called to testify, you'll say you were moving fast?
I'm talking allegedly. By his account, man, I wasn't there.
Right.
When I left in the afternoon, she was still alive. The cop is lying.
All right, look, I'm not saying the DA will go for a plea, but if I can get...
No! I want you to beat it. One eyewitness at nighttime, man, you gotta be able to make reasonable doubt on that.
$6 months. On each count? No, total. What? This is a liberal judge, and he can go easy on sentencing. But, and this is important, he's probably going to tell you a story about Ray Charles.
What you mean about Ray Charles?
He lectures defendants. His favorite is the Ray Charles story. It's corny, but you have to take it seriously. I had a defendant snicker once, and this guy doubled the sentence. I want you to think sad thoughts and just get through it. And show remorse.
Okay.
You take responsibility for the crime. Don't be saying you never had the drugs.
Got it.
And whatever you do, don't laugh.
I'm looking at prison time, Mr. Berluti. Ain't gonna be no laughing.
She was unconscious. You were afraid of how it might look. You put her in the car to make it look like a suicide. It's what happened, isn't it?
This is the part that kills us. That's the bomb. This tape got admitted for impeachment, which prevented Scott from testifying.
You mean it made you keep him from testifying?
Right. I don't want to be in that position again.
If the judge let it in once, what makes you think he's going to change his mind now?
Judge Wolf isn't the judge for the new trial. We drew Judge Hiller.
I was responding to a report on a possible shooting. When I arrived at the house, I saw the defendant leaving the side door of the house, running.
This man.
Yes.
What did you do next, officer?
I entered the premises and discovered the victim, an African-American female, approximately 30 years of age, with what apparently was a single gunshot wound to the head.
She was dead.
Yes, ma'am.
When did you next see the defendant, officer?
2 days later, I identified him in a police lineup as being the man I saw fleeing the house.
Thank you.
To your knowledge, sir, were any fingerprints found on the gun?
The gun was never retrieved.
Was any gunshot residue found on my client's hands?
No.
To your knowledge, was a trace metal test done to see if my client had even held a gun?
The test came back negative, but it was 2 days later.
Thank you, sir. You said you picked my client out of a police lineup. You recognized him?
Yes.
In fact, you had met my client before, hadn't you?
Once.
You had responded to a domestic conflict before at his residence?
Yes.
When you saw my client in the police lineup, is it possible you recognized him because you had met him before?
No, I recognized him both as a man I'd met before and as the man I saw fleeing the house the night of the shooting.
So the man was running out a side door?
Correct.
Toward the front of the house or the back?
The back.
So he was running away from you?
I got a good look at him.
He was running away from you, sir, at night?
I got a good look.
Why were you playing out of position?
What?
That's the term when you're outside your assigned area. A call came in of a possible shooting. You said you were on it, but you were outside your patrol area.
I wasn't that far outside my area.
You weren't the closest unit?
No.
Why'd you take the call?
I recognized the address.
Why were you playing out of position, officer?
I don't remember.
You don't remember?
My client has been in drug programs. He's clean. He hasn't been using. He's willing to do community service upon release, Your Honor. In fact, it's something he wants to do.
And the Commonwealth is okay with 6 months?
We feel it's a little light, but we're not opposing.
All right. Step back. Mr. Babbitt, please rise. And before I sentence you, young man, I want to talk to you, not as a judge, but as a teacher, and perhaps as a friend. I know that young men like you rarely have the benefit of a male influence in your community. Well, maybe for this one moment, in this very special place, I can be a father to you and a friend. I'd like to tell you a little story, a true story. Now, many years ago, a little child was born in the South. Poor, hungry, black, no direction. And more than that, he was blind. But this boy had a gift. His gift was music. People loved to sit and listen to this boy play the piano. But like you, he had a monkey on his back. The monkey of drug addiction. He was addicted to heroin. Lord God, he loved the needle. But you know what? Blind, black, addicted to drugs. He beat his monkey. Beat it, I tell you. And he went on to become a beloved American, a hero, a black, blind American hero. And that man had a name, son. His name was Mr. Raymond Charles. Now let this be the first day of the rest of your life, young soldier, a drug-free life. Go forward to make this world a better place.
I'm sorry. I'm sorry, Your Honor.
You think this is funny?
No, sir.
Well, I'm not impressed with your disrespect, Mr. Babbitt. Perhaps you're not quite ready to go back into the world.
Your Honor...
Never mind, Mr. Berluti. The defendant is sentenced to 18 months at Cedar Junction.
18 months?
Bailiff, take the defendant into custody. We're adjourned.
Let's go.
His personnel file?
Well, I see he's receiving psychiatric treatment.
That would be totally privileged.
Ordinarily, yes. But sometimes the courts have looked into the records of police officers when they're relevant to the case.
And what would be the relevance here?
I don't know, Your Honor. But you saw him up there. He's hiding something. And if there's anything in those files that goes to his credibility, I should be allowed access.
You haven't made any showing, and you can't make any offer of proof that there is anything.
Helen, come on. I just got this case with my morning cup of coffee. And I know Your Honor doesn't want to give this world-class citizen any grounds for appeal.
I'll tell you what, I will look at the report. If I see anything that's relevant, I'll let you look. Otherwise, forget it.
Taken out of context, it looks like an admission.
It was in complete context. What's more, silence is admissible. Failure to respond to an accusation made against you can legally be considered an admission.
First of all, that begs the conclusion that this was a voluntary communication.
Did your client not get Miranda?
He did, but he was in shock at the time. I have submitted to the court 3 psychiatric reports which question the voluntariness...
Oh, please, Mr. Donald. Defense lawyers can hire psychiatrists all the time to proclaim he didn't know what he was saying.
We have a man whose wife was found dead. And he was still trying to absorb that when the police suddenly handcuffed him. Next thing, he's in the room with a district attorney. A district attorney who now believes he's innocent, by the way.
She never said that.
It's too prejudicial to allow a jury to see it. It would bias them.
What Mr. Donald is saying is he doesn't trust juries. Well, that's the system of this country, and if it displeases him, perhaps he should move to Cuba.
Mr. Bay, did you see the sign, "Check your soapbox" at the door?
No.
Do I need to hand one?
The bottom line question is whether the potential prejudice of this tape outweighs its probative value. The answer is yes. Let them try Scott Wallace on the evidence. And the evidence alone, not an emotional breakdown which occurred in the wake of an unimaginable tragedy. This man is in a psychiatric ward as we speak.
How convenient.
You know what, Richard?
All right. I've heard the arguments. I have your briefs. I'll take the matter under advisement and I'll rule. Thank you both.
It was totally my fault. I kept telling him not to laugh. I think I put so much pressure on him.
Why would you have to tell him not to laugh?
Well, he gets extremely nervous, and laughing is a reaction he has. That's why. I was so afraid he might get nervous and laugh here. I kept hounding him, and I just made it worse. He wasn't laughing at what you were saying, Your Honor. I promise you.
He sure seemed to be.
He's a nervous kid. He's facing jail. Who's gonna laugh at that? To triple his sentence? Please, Your Honor.
All right. I'll have him brought back in. We can re-sentence. But I'm giving you and your client a break, Mr. Berluti.
I understand that. And I'm very grateful, Judge.
My medical file?
If the judge thinks there's nothing relevant, they'll stay sealed. What's wrong?
I've been married 17 years. I have kids.
Paul, what's the matter? What's in the file?
I'm gay. When he said playing out of position, I thought for a second he knew. So I froze up there on the stand.
It is totally irrelevant.
That's my call, actually. But thanks for your input.
Well, I'm not so sure it is irrelevant. If this situation caused stress, which affected job performance...
Well, it didn't.
That's what it seems to suggest.
His sexual orientation did not impair his ability to make an ID of a fleeing suspect, Eugene.
Helen, this whole case turns on the credibility of this officer. If he was dealing with severe stress, I have to be allowed to cross-examine him.
First, this is so collateral.
I disagree.
And second, it will ruin the man's life.
And the conviction ruins another man's life.
You really want to go down that path?
Your Honor, you want to take me off this case? Fine. But as long as I'm on it...
You will be despicable.
I don't need that.
All right. I will let you introduce that he was receiving psychiatric treatment for stress. The cause of that stress is off limits.
I'd like to read the report.
Denied. And Eugene, you are not to even share this information with your client.
I don't think you can order that.
I just did.
So how are you feeling?
I'm feeling better, Bobby.
You look better.
I'm feeling good.
No more spots?
I want her to get you a couple of new suits for trial, so she'll need to take some measurements.
Oh, this time I testify, right?
Well, let's see how the ruling goes on the videotape, but hopefully you'll testify yes.
Oh, you got any good news? All I give you here is Jell-O, damn it.
Second trials typically favor the defendant. There won't be any surprises this time, Scott. We'll be ready for Kyle Barrett.
Good. Excellent. Good.
And I just want to apologize to the court if I showed any disrespect. It wasn't my intent to offend you.
I understand from your attorney that you couldn't control yourself.
That's right.
All right. But before I resentence you, I'd like to tell you a little story about a woman who, like you, lacked control sometimes. Like you, she had an addiction. Her addiction was gambling. Like you, she wanted the fast life with fast cars. But she only got those things when she learned to control herself and beat her addiction. When she learned to work hard, and she did work hard, young man. She had the voice of an angel, and with her golden voice and hard work, she too beat her monkey. And that woman had a name, son. Her name was Miss Gladys Knight.
I'm sorry. I was thinking of something else.
Me too, I promise.
The defendant is hereby sentenced to 12 months on each count. The sentences to run consecutively.
2 years?
Bailiff, take the defendant into custody. We're adjourned.
Testified before. These lawyers trick you. What if he twists one of my answers and says I opened the door?
I will protect you. You have my word.
This Eugene Young has a reputation. What does he care if it's called a mistrial? For him,
Paul,
he'll do anything.
within the law. Judge Kittleson was very clear in her ruling. Mr. Young will abide by it.
Listen, you just answer yes. I suffered from stress and I sought treatment. It didn't affect me that night. Keep it as simple as that, but do not lie. Because then he can get in the other stuff through impeachment. Just answer the questions, don't elaborate, and I will protect you.
I have read both your briefs. I also watched the videotape again, and it is my conclusion Judge Wolf erred, allowing the tape in for impeachment purposes. His legal rationale escapes me. This tape is outright admissible altogether. I'm permitting prosecution to use it as evidence. Mr. Donald, if you think the statements or conduct of Mr. Wallace were a result of shock or trauma, you're free to raise that in your defense. That is all. The trial will begin next Tuesday at 9 a.m. We're adjourned.
We'll get our witness list by the end of the day. I don't expect it to change. The transcripts are in. I'll have copies sent over.
Thanks.
to file a writ. If that tape...
Bobby, it was the right ruling.
I should at least try.
No, you shouldn't. We have 6 days to get ready for trial. You can't waste time on writs. Let's focus on what we can win now. You start preparing the psychiatric experts. I'll go over the transcripts with Eleanor.
I'm obviously pleased with the ruling. The Commonwealth has always felt that the statement was a de facto admission and that it was evidence. I'm satisfied that a jury will now get to consider that evidence. That is all.
Officer Brewer, have you ever made arrests where the district attorneys have refused to prosecute?
Of course.
How many times?
I'm not sure.
More than 5?
Yes?
More than 10?
Sometimes there's insufficient evidence.
More than 20?
Objection. What's the point of this?
The point is this officer sometimes claims a crime has been committed only to have the DA say otherwise.
A district attorney's decision to dismiss often turns on the prospect of getting a conviction. It's not about overruling the arresting police officer.
Well, sometimes it does involve the honesty of the officer, and that's what I'm trying to explore.
I'll allow it.
Officer Brewer, how are you on the issue of honesty?
What is that supposed to mean?
Are you an honest person, sir?
Objection. Sounds like badgering.
Every witness, by testifying, puts his credibility in issue. And I'm allowed to explore this man's reputation for truthfulness.
The objection is overruled.
Do you consider yourself to be a truthful person, sir?
Yes.
You live a truthful life?
Objection.
Sustained.
Are you receiving psychiatric treatment, officer?
Yes.
Does one of the issues for which you are receiving treatment concern your ability to be truthful?
Objection.
Overruled.
It's beyond the scope.
I'll allow it.
Do you have trouble being truthful? I'll repeat the question, sir. Do you have trouble being truthful?
Yes.
In fact, you lie every day, don't you, officer?
Yes.
One of the reasons you sought psychiatric treatment is you were afraid your lying caused you such stress that it perhaps started to affect your job. Isn't that right, officer? Did you not hear the question, sir? I can repeat it.
I heard the question. The answer is yes.
Thank you, officer. I have nothing further.
Mr. Beluti, I'm not interested.
Your Honor, 1 second he's about to get 6 months. Now he'll do 2 years? You know that isn't right.
Well, maybe next time that will mitigate your amusement when...
I apologize.
Apology accepted, but the sentence stands.
It's one thing to exercise discretion. It's another to flaunt your ego, and this...
Mr. Beluti, you are 2 seconds from contempt. And before you go skulking out of here, thinking of me as the bad judge, keep in mind that I was about to help your client, not only with a lesser sentence, but also with some advice that could help his life. Now, you defense attorneys get them off. What do? They go right back out and commit another crime. I try to reach them, and I do. I tried to reach your client, to offer his life some direction, like I have with so many before him. And he laughed, as did his attorney. Maybe it's your ego that needs adjustment.
I laughed because I've heard the Ray Charles story a zillion times, as have all the lawyers who appear before you. We all tell our clients it's funny. We all tell them not to laugh. We're all afraid they might laugh because it's so ridiculous. It's a joke, Your Honor. Poor, black, blind, this man had a named son. It's paternalistic, insulting, and all the lawyers laugh at you. I just made the mistake of doing it in the room. If that buys me a jail cell for contempt, so be it. But that's what's going on. You're naive to think you reach defendants. And if you punish them out of anger,
you're also a bad judge.
Mr. Beluti, I will ask you once again to leave my chambers.
I'm filing a motion for reconsideration anyway, even though I can't stop you from doing what you're gonna do.
You said you would protect me.
Everything he asked was arguably within the proper scope. I tried to shut him down.
You said you would protect me.
Well, I couldn't. Listen, Eugene Young is a very smart lawyer. He doesn't want the jury to know that you're gay or what the lie is actually about. He knows the jury would just dismiss it as irrelevant. Look, I'd like to introduce what you're untruthful about.
Excuse me?
Paul, if we don't fill in some of the blanks for the jury, your credibility is shot with them. If we tell them what Eugene is talking about, they'll know you're not dishonest.
And my family will know I'm gay. My partners will know. My life, my career.
You're basically the only witness we have. If we don't reestablish your credibility, I can't convict here. Paul, the guy shot and killed a woman.
No. I can't do what you're asking me to do.
Well, I don't need your consent, really. I'll figure out a way to get it on redirect if I have to.
You gonna out me, Miss Campbell?
I don't know if I have a choice.
Yeah, you do have a choice, and so do I. If you... I'll recant. I'll say it wasn't the defendant I saw that night.
No, you won't, Paul. You're an honest man.
No, I think Mr. Young established quite clearly that I'm not.
If you commit perjury, your life and career truly might be over.
I'll make my life decisions.
And I'll make mine.
And I would submit to the court, given all the circumstances, and especially that the Commonwealth and the defense have submitted a joint recommendation.
That's all it is, Mr. Beluti. A recommendation. Either for the judge to accept or reject. I have chosen to reject it. And I find myself very annoyed that you are back before this bench with nothing new. If you have nothing new to tell me, this hearing is over.
What's new? In addition to appearing as counsel for the defendant, I am here as an officer of this court. I am standing up for the integrity of this room. You were prepared to issue one sentence, then gave another because you got angry. You're entitled to belittle yourself as a man and as a judge. But when you belittle this room by abusing your discretion, I'm entitled to have something to say about it.
Is that all?
No, sir, it is not. I want to speak to you, not simply as a lawyer, but as a friend. There was this judge. She wasn't very judge-like at all. She had terrible manners. She rambled on the bench. She had a big mouth, and she was obnoxious. And she had an ego. Lord, she had an ego just like you, Your Honor. She also had a gift. She had the voice of a crow. And she beat her monkey. She relished being obnoxious. She was proud of mistreating people. And she used her ego and her crow-like voice to make millions of dollars. And she had a name, Your Honor. Her name was Judge Judy.
Mr. Beluti, you are in contempt of court. Bailiff, take him into custody.
Officer, how many times have you testified in criminal proceedings?
Probably over 40.
Have you ever been accused of perjury?
No,
Ever had a case of yours thrown out because of unreliable testimony on your part?
not one.
You also testified that you see a psychiatrist.
Yes,
Do your supervisors know about it?
my watch commander does.
Has he changed your assignments because of it? Put you on desk?
No,
You admitted to Mr. Young that you lie almost every day.
about a personal matter, yes.
Did it affect your work on this particular case?
No.
Did you lie about what happened the night Tasha Cooper was killed?
No, I did not.
Have you ever lied in your capacity as a police officer?
No, I have not.
When it comes to making observations, making arrests, giving testimony about those arrests, do you consider yourself to be a truthful person?
Yes, I do.
Who was the man you saw fleeing the house that night?
That man. There, the defendant.
Thank you, officer. I have nothing further.
It's a setback. I won't kid you.
Is this judge going to go against us?
No, she's extremely fair. She won't do us any favors, but this case won't be decided by her. This time, you will have to testify.
I'm ready.
I can handle all the witnesses. We're in good shape there. But that videotape and your response to it on the stand, that's what will decide this case.
I have better focus now, Bobby. I mean, before I was still in grief. You know, I couldn't believe she was gone. But now, when I think of what she did, I mean, killing herself right after we had a fight, I mean, that was an angry act, Bobby. I mean, that wasn't depression. She was doing it to me. That was hateful. And right now, I hate her. Scott, I hate her, and I'm not gonna lie in some wallow any longer. Everything is easier now being angry at her. I have my focus back. I hate her.
One eyewitness who sees a man at night from the side running away from him. Could he describe him? Black, medium build. No clothes, no distinguishing characteristics, just black, medium build. A black man in the dark running away 3-4 seconds, but he got a good look. Now, we all know what happened here. That man saw somebody running. He then sees the wife dead, figures it must have been the husband he saw going out the door. He then picks the husband out of a lineup. But that was easy, because he had met the husband before. No weapon. No gunshot residue on my client's hands. Nothing to suggest he had even held a gun, much less fired one. That police officer made a guess, and he's sticking by his hunch. That's what this is, and we all know it. 1 3-second ID in the dark by a self-confessed liar, that isn't proof. Their whole case comes down to the say-so of a man receiving psychiatric treatment to deal with stress caused by his inability to tell the truth. Do I really need to stand here and tell you there's reasonable doubt?
No other prints, no DNA, no physical or testimonial evidence to even suggest that anyone else was in that house that night. No other cars in the area. The intruder fled on foot. It was that man fleeing the house. Officer Brewer saw him. He was unequivocal in that. The defendant Brian Grant was the man he saw leave that house. Defense has offered neither evidence nor testimony to shake that ID. All Mr. Young could seize upon was some psychiatric treatment that Officer Brewer is undergoing for a personal matter. Yes, he lies about something in his personal life. Big deal, we get that. But he doesn't lie as a police officer. It doesn't make him an unreliable witness. In fact, in 21 years, Officer Brewer has had an exemplary record of honesty on the force. He's never given untruthful testimony. He's never been a false witness. His honor has been beyond reproach, just as his testimony is here when he tells you that's the man he saw leave that house. You haven't heard one word suggesting that anyone else committed this murder. Gee, I wonder why. He's home alone with his wife. He shot her. He's seen running out. That's why we're here.
Go. The only reason I don't keep you overnight, for what I deem to be criminal disrespect. How long have they been laughing at me?
Long time. How long you been telling that Ray Charles story?
At least I try to do something. I care, at least. Most judges. Tell your client I'll give him 6 months. Beat it.
That's it?
You want a story, first counsel?
No.
Just go.
Came back kind of fast. That mean anything?
Usually it means it was a quick decision.
Mr. Grant, the court will ask you to stand, please. Mr. Foreman, has the jury reached a verdict?
We have, Your Honor.
What say you?
Commonwealth versus Brian Grant. On the charge of murder in the first degree, we find the defendant, Brian Grant, not guilty. On the charge of murder in the second degree, we find the defendant, Brian Grant, not guilty.
Members of the jury, your service is completed, and we thank you. The defendant is free to go, and we are adjourned.
Wow. Thanks, man.
Sure.
Innocent till proven guilty. The motto lives.
See you next time.
Good one.
I'm sorry we didn't get him.
Yeah,
Did our best.
Miss Gamble. Thank you.
I wish you well, Paul.
You too.
I really appreciate you coming in with your client.
It's against my better judgment.
I totally understand. It's just lawyer to lawyer. You're aware that Helen Gamble believes your client committed perjury in the first trial.
Ms. Gamble was mistaken.
Yes, well, I don't believe she was.
Mr. Donnell, I'm confused as to the agenda here. Certainly
the
we
agenda
could have...
is this. I'm putting you on notice. If your client takes the stand again and lies, I'll be taking his house.
Bobby?
Tell him, Mr. Stone. Tell him the exposure he faces. Abuse of process, false imprisonment.
I don't know what you think you're doing.
If he lies again, I'll be filing a complaint against you for suborning perjury.
I'm reporting this to the district attorney's office.
You do that, but in the meantime, get around to giving your client some legal advice.
Come on, Kyle.
Tell him what I'll do to him, Mr. Stone. Tell him.
You just crossed the line, Mr. Donnell.
We're just two lawyers talking, Mr. Stone. Just you and me.
What the hell do you call that?
I call it intimidating a lead witness for the prosecution. I gotta keep that lying bastard out of the witness chair.
You've got a lawyer in there who just threatened my client.
Really? With you there? Call the police.
Come here.
I came to congratulate you.
And I get a personal visit for that.
That. And the police just got into a shootout with the man who fired back with the gun used to kill Tasha Cooper. He matched the description of the suspect Officer Brewer